So I wanted to do a follow-up video regarding court corruption. This is in District Court, Southern District of Ohio, Western Division at Cincinnati. This is in federal court. I wanted to put this in perspective so everybody knows what's at stake here. So this can happen to anybody, whether it's something dear to your heart, whether someone has taken your kids away, CPS, maybe you have an evil ex called CPS on you. Maybe it's a house you've lost, but basically it's not your fault, and you have proof that it was all false. And in my case, one of the state prosecutors, hid a bunch of evidence against me, and I found out because I ran a public records request for it, and I obtained a bunch of records I'd never seen before, and unfortunately it was too late. I didn't know about it. So during the habeas proceedings, the opposing party, which is the Ohio Attorney General's office, which represents the state of Ohio in federal habeas, there was a discovery demand by my attorney, and one of the prosecuting attorneys provided his discovery demand, and it was really brief. There wasn't that much information in there. He did not sign his name at the back of the motion. What he did was he actually just slashed a line through it. And many, many years later, I ran this record request and I found out, well, he withheld a bunch of evidence against me. I brought this up during my federal habeas proceedings, and the fact that the opposing party actually saw this document, it was never signed. And what I did was I put in all the records showing that this was a sham and false document, and that the opposing party knew about it, because she did go through each and every document and redacted personal identifiable information, like under HIPAA. So she clearly observed it. I put in all these records showing it was a sham and false document, and I was asking that the court equitably toll my claim, because that's what you can do. And so what you do is you raise a motion, and you can vacate an earlier order that the opposing party knew about this. And as a matter of fact, I actually had some of the records that pointed to the fact that the Ohio Attorney General's office possessed a rape kit, and they conducted a joint investigation with the county prosecutor's office. So I had this record, and I put in a motion, and I was asking the court to look at this, because Maura Jade, which is the opposing party representing state of Ohio federal habeas, she would have freely known about this stuff, because the results of this rape kit was actually sent to BCI, which is through the Ohio Attorney General's office. And so I put in all this in the motion. Magistrate Merz, which is federal judge, said that he doesn't want to see these records, so he denied it. As far as any claim that there was fraud upon the court, I got a decision back from, his name is Timothy S. Black. So here's the decision in order. So basically what this is a game. They're playing a game where they're saying that the court does not have any inherent authority to conduct an evidentiary hearing to determine if there was fraud on the court. So in essence, they're saying we don't have authority to investigate ourselves. We're helpless. We're completely helpless to investigate any fraud allegations. So I'll actually point this out in the order. So this was on January 3rd, 2024. Case number 113 CV 00928. It's Doc 108. And interesting enough, all this evidence that I put in here in my motion, he is not explaining anything that I put in the record. So he completely ignored it, all the evidence. Here's what he said. Hobbs offers no proof of Attorney Jade's asserted mendacity beyond the rejected inference. He claims he can prove if granted an evidentiary hearing, but such hearing is precluded by Supreme Court precedent, Collin versus Penholster. So he denied my motion. Well, here's the problem with that. Actually, there was another order in this case by Magistrate Merz 2 times. He put in an order for this court, and he said, pinholster does not preclude a hearing for fraud upon the court. This was twice before Timothy S. Black, the same judge who denied this. So he is disregarding an order of the court, and he is saying Cullen versus Pinholster does not allow a court to investigate fraud upon the court. All this evidence I listed, it's nowhere in this motion. He did not cite anything. He did review it. He saw it. So this is the type of games that happens in federal court that will erode public confidence in our system. Okay, they're supposed to be fair and impartial. I'm clearly putting in a bunch of record. I put in, I believe it was 15 pages of records showing that the state prosecutor did not comply with his Brady obligation, that document that he signed was sham and false. So he did not cite anything. He's not being fair and impartial to me. So this is why I'm clearly upset here. This is absolutely ridiculous. I'm mad because I have a lot at stake here. This is 10 years old. This case has been in court for over 10 years. I have been litigating this case for over 10 years. I'm tired of this. This is absolute bullcrap. Okay, so I really wanted to put this in perspective so that everybody hearing this video can tell that I am not only upset, but I mean, these are games that they play in federal court, you know, and something is dear to me, you know, that I've been fighting this long, and anybody else, you know, that's had something taken away from them and it's all false and sham and it's falsified and you can prove it. I mean, I have witnesses and, you know, I have put in these documents, and through a hearing, I can develop my claim that there was fraud upon the court by Maura Jate, which is the opposing party. Everything I put in my motion regarding what she knew, it's not even in this order. He did not even look at the records or anything. It was on the act. I appended it to it as exhibits to the motion. So he clearly did not list it because he doesn't want anybody know what I actually have that would allow a hearing on this matter. So, and the decision he cited, again, Cullen versus Pinholster, does not apply to claims of fraud upon the court. So not only did he read that decision, there was previous orders in this court saying that an evidentiary would never be barred for any type of claim of fraud upon the court. So I also want to mention another thing. So I filed 2 complaints with the Circuit Executive, which is with the 6th Circuit Court of Appeals, against this judge. And I got back a decision saying there's no misconduct regarding not following the law. As far as this all being a publicity stunt, which it is, granting political favors to a opposing party, because that's what he's doing here. And basically not obeying the substance of that complaint was that he was disobeying orders of this court. And again, it was denied. And I also found out that basically the presiding judge, the circuit judge, reading my complaints was actually a judge in that court as well. So before he became the circuit executive, he was another judge. So your whatever complaints you have, it's not going to go anywhere. Okay, unless it's something clearly ridiculous and it erodes confidence in our system, I think they might take action. But for low-level type corruption, they're not going to do anything. So all my complaints were dismissed. And as far as appealing it, you need a certificate of appealability. They said they denied it in here, and they want me to apply for the 6th Circuit to allow me to appeal, and I'm not going to do that because they're just going to use that as a reason. They're going to cite case of the law doctrine, which means that any decision by a higher court you're bound by that decision. That's what they want me to do. They want me to appeal it and try to get a certificate of appealability, and then they're going to make an error of law or whatever, deny it, and then they're just going to cite it. And I'm not going to do that. I'm going to keep it down at this level, and I'm going to keep fighting this case. But yeah, I just want everybody to know this has been in this court for 11 years. I've been litigating this on and off for 11 years. Okay, that's a lot of paperwork. That's a lot of research. These are games that they're playing. All that they are doing is just putting pen to paper and just thinking that that paper is some type of judgment or something. It's not. It's a void judgment. So these are all games that they want to play. They're not reading anything that I file. It's disrespectful to me. It's disrespectful to anybody else who goes in front of the court thinking that you're going to have a fair and impartial proceeding. You're not. Okay? Again, this motion was against Maura Jate, the Ohio Attorney General. She works with the Ohio Attorney General's office, and I did write a letter to her informing her to investigate this sham legal document she put in the record. I raised it before the court, and the fourth motion, you can tell right here, I put it in there. Clearly, they're not reading anything that I'm putting in. You know, I'm really ticked off. This is taking a toll on me. You know, just someone seeking justice, just trying to get a hearing on this matter. But I'm going to go back to court on this matter. My next motion is going to be finding this judge guilty of fraud upon the court. These were previous orders of the court, which told Timothy S. Black that pinholster does not apply to my claim. He keeps going back saying it does. It does not. I read the decision. I put it in my motion saying it does not apply. Magistrate Merz said it does not apply, and he wants to say it does. So it does not apply. He did read it, and he understands it. Anyways, I'm going to try to get this on the news station as well. So I'm going to get some coverage on this case. I do not appreciate being treated like this in this court. I mean, this is a federal court. Corruption has no place in our courts. I don't want this happening to someone else as well. So this has to be exposed. All right. Thank you for your time.